Welcome, everyone, to this presentation on the removal of the pre-occupancy addendum form and the addition of a new post-closing lease addendum form to the Bluegrass Realtors form directory. My name is John Rompf, and I'm an attorney at the law firm of White, McCann and Stewart. I've had the privilege of working with both the Forms Committee and the Board of Directors on this update that I'm excited to share with you here today. I'd like to begin today with a disclaimer by letting you know that neither this presentation nor this new form are intended to be legal or tax advice for any particular situation or real estate transaction. I would encourage anyone watching this presentation to contact the appropriate professionals for any legal or tax questions they may have about the use of this form for any particular situation. I think this is particularly true as it relates to this presentation, as the form being discussed creates the relationship of a landlord and tenant between buyers and sellers. The laws and regulations regarding such relationship vary greatly throughout the Commonwealth of Kentucky, and I would strongly encourage you to advise all consumers, whether they are buyers or sellers, to consult with an attorney located in the jurisdiction where their property is located before they agree to either a pre-occupancy or post-occupancy agreement related to the property that you're advising them on in a real estate transaction. It's incredibly important for them to be familiar with the local rules and regulations and how local judges operate. And this is getting outside the realm of a real estate purchase contract and into the realm of a lease agreement. And the specific locale will have a tremendous impact on what will happen in the event the parties cannot agree and what courses of actions and rights of remedies they're going to have. So local counsel will be very, very important. With that said, I'd like to begin today with a discussion regarding the decision to remove the pre-occupancy form from the forms directory of Bluegrass Realtors. I think of the reasons kind of being the three L's. I'll start with litigation. I know from my own practice and from monitoring litigation cycles in the area that one of the most heavily litigated issues as it relates to forms of the Bluegrass Realtors are pre-occupancy agreements. These forms or these situations where the forms are utilized are often when parties end up in court, whether it's due to buyers having remorse over their purchase of the property or something breaking or the discovery of something that buyers feel like wasn't disclosed. Pre-occupancy situations before closing are very heavily litigated because the parties feel as though they still, I think, have leverage before the closing occurs. So in the litigation practice of our firm, this is the most common call we get is either how do we break our agreement based on a pre-occupancy or how do we enforce, make a buyer continue towards closing when they don't want to if we're getting a call from a seller. So one of the ideas here is to remove a form that causes a lot of litigation and also a form that is not becoming the norm in terms of being offered by other real estate associations and MLSs. So it's becoming a best practice in the industry for agents not to be involved in this process. And part of that probably has to do with the second L, and that's liability. When you have a pre-occupancy agreement, as many of you know who have participated in such arrangements, agents end up in the middle of property management. They end up fielding a lot of communication questions related to the property. Can I paint? Do I need to repair this? Who has to pay for this thing that broke? And obviously, if it's a short-term, 24 hours, those issues are less likely. But when you creep into a long weekend or a week, those issues start to come up. And real estate agents are put into a position of property managers. And although some brokerages do that kind of service for clients, a lot do not. And a pre-occupancy form in its very nature, due to agents' fiduciary responsibilities until the transaction closes, puts agents strictly in the middle of that. And it requires a lot of skill sets and dealing maybe with insurance and things like that, we believe as an organization, it's not good to create the presumption of agents having to do. We also are aware that sometimes brokerages' insurance policies or individual agents' insurance policies won't cover them when they're acting in this capacity without specific riders for coverage. And so one of the ideas here is to not allow agents to find themselves in a situation where their professional insurance may not cover them. And the final L is what I would talk about as a lack of necessity. a pre-occupancy agreement is never going to be a necessary condition to closing. Is it often a convenience, something that the parties negotiate and it affects the whole transaction? Certainly. But unlike a post-occupancy agreement, where agents can be removed from the process, once you close, the agent can be outside of the process at that point. With pre-occupancy, again, the agents are necessarily going to be involved. And creating a form that requires that of agents kind of creates a presumption and an endorsement of that kind of course of action on the behalf of Bluegrass Realtors. And we believe that at this point in time, given the way the rest of our market is adjusted and the way other folks have kind of interpreted this and seeing how it impacts litigation, the decision was made at this point to remove that pre-occupancy agreement from the forms directory. Obviously, parties always have freedom to contract, but because of, I think, these things we've discussed already today, the increased likelihood of litigation, the potential for liability on agents, and the fact that it's, a very nuanced thing that isn't always necessary to get you to closing, and we can keep agents outside of it. I would encourage anyone who wishes to kind of continue to explore this course of action to do so at the advice of local counsel in the jurisdiction where the property is located. I think that's the best way to protect yourself. It's the best way for your clients to be protected in the event such pre-occupancy were to fall apart. So with that said, I am going to move on to an introduction of a brand new form. This is going to replace our post-closing document that currently exists, and this is a new post-closing lease addendum. This is an attempt, again, to provide a convenience for the membership to have a tool for their consumers to use in circumstances where a seller is going to remain in possession of the property following closing, and it's going to create a form that can be utilized. I'm going to reiterate, and I know I've said it 3 or 4 times already, but I would strongly encourage agents to advise their sellers or their buyers before using this form about consulting with local attorneys. The landlord-tenant relationship, we have different laws throughout the state, depending on where the property is located. Different judges handle evictions or forcible tainter actions in very different manners, and different court systems require different rules and regulations before parties can assert certain remedies. This form is not intended to take care of all of those situations. It is impossible, actually, with one form to make it legally compliant everywhere throughout our areas of operation. So this form is meant to be a tool, but it should be done in conjunction with the advice of a competent attorney in the jurisdiction where your property is located. I cannot emphasize that enough, is that the residential lease agreement creates certain rights and remedies and responsibilities for buyers and sellers, and they need to carefully consider whether or not they want to accept those roles and responsibilities prior to executing this form. And the only way for them to truly have the knowledge and the understanding of whether it's a good idea is to consult with an attorney in their jurisdiction. So with all of that said, I'll move on to kind of the specifics of the new form. First, I would point to the top. If you've watched any of our other videos on the release of the new forms, you'll notice that this post-closing lease addendum also has an updated kind of disclaimer at the beginning of it. The main thing I'm going to highlight again is that a lease relationship also can have tax consequences. Parties should consult with their tax advisors about how this may impact their tax situation, and they should do that at the onset of the transaction. So that's new language in all of our disclosures now, is the importance of talking to tax advisors, and I would certainly encourage them to do that. The second thing is that I would let people know that we're creating a form here that does create a new relationship, that of landlord and tenant, and they need to be advised about what that means for them as it relates to their transaction. The next section of the form that I want to talk about is really how we see this form playing out. And we do expect, yes, it's going to be interrelated with the contract. It's going to be tied to the contract. We want the language used in the contract to have the same meaning in this agreement. But this is going to be a separate agreement that we really would advise people that not actually be executed until closing. And the reason for that is that agents' duties and responsibilities, even though you may go above and beyond, they terminate at the closing of the transaction. And this is going to be an agreement not between the brokerages, not between the agents, but between the parties themselves. And it's important for them to understand that. And the best way to kind of hammer that point home, I think, is for this, to be provided to people as a tool, but for agents to step outside and not be involved in other than to advise them, here, this exists, but I would consult an attorney about it. We want to make sure we're not, as agents practicing law, we're not giving advice about kind of uh, how to manage a post-closing relationship between the parties. The next section makes that very clear. So we kind of explicitly stated this should be completed at the closing of the contract. And we're at that point in time going to have buyers and sellers share their information with one another. They're going to be in a relationship. The agents are going to be out of the transaction at that point. The buyers and the sellers are going to be in a position, if they want to enter into an agreement like this, where they really need to have effective and direct communication with one another. So the purpose here is to disclose that information, and obviously we don't really want to do that before closing, but parties need to have contact information if they're going to deal directly with one another on issues that may arise under a post-occupancy agreement. The next section, paragraph 2, is intended really to create the termination date of when the post-occupancy is going to end. So this is the fillable part of the agreement where the sellers are going to need to, and the buyers, they're going to need to agree on a date of termination. And that's important because, as everyone knows, when the new buyer wants possession, they want possession, and they need a, kind of an end date where they know where the relationship is going to, cease and the seller is going to vacate. That's the primary takeaway. This is a fillable part that would need to be completed in order to make it legally effective. It's going to create the term, and leaving that form blank, or leaving this portion of the form blank, would have significant legal consequences. So it's something that has to be filled in. The next section kind of creates some obligations upon a seller until it vacates the property, and obligations on the buyer. So the first section is section A, and section A is at the bottom of page 1. It'll be at the top of page 2, but it talks about responsibility for insurance. And this is something that needs to be understood by parties entering into these agreements, that the insurance for the property is going to have to change, or more than likely is going to have to change as of the date of closing. The buyer is going to want to be absolutely certain that the premises is insured and that they're protected for fire and extended coverage. And sellers are going to want to make sure that their personal property continues to be insured. And the way to do that is for them to obtain basically a renter's insurance policy to make sure that post-closing their personal property is going to be insured. So 3A is aimed at making sure all those insurances are in place and that the parties understand who is responsible for what coverages and what their obligations are in terms of naming additional insured and taking care of personal property. You'll see at the top of page 2, it's creating a requirement, again, for the seller to go ahead and get that renter's insurance and making kind of minimum requirement sets in place. And obviously, this is things that could be negotiated between the parties, but this is creating the presumption of minimum insurance policies. The next paragraph is creating the obligation on the seller to keep the property in basically the same or better condition as it was at closing. Again, we envision this form being utilized in circumstances where the agent is going to be outside of the transaction at this point. Obviously, most of you utilize the best practice of having a final walkthrough where the parties sign off on the condition of the property. And this is removing the agents from that point forward. So the parties close. We have a snapshot in time of what the condition of the property is going to be. And the parties agree that it's going to be maintained in that condition until possession changes. And that's a very important thing. I'd again advise you, this specific clause can have very different requirements on the parties depending on where the property is located. Certain jurisdictions within the Commonwealth require very specific documentation related to the condition of the property if you're going to make a claim that it was not properly maintained. So I would again encourage folks to consult with legal counsel in their local jurisdiction. The next section is, one of the more important ones, and that's talking about what is the compensation or the rent going to be to the buyer for allowing the seller to maintain possession. We've tried to create some flexible options, but this section would also, again, need to be filled out very clearly. Even if it's filled out with $1, there needs to be some consideration for the transaction in addition to the real estate contract itself. Legally, you probably could have it be 0, but I would encourage folks that the best practice would be to have some amount of rent. And the reason for that is whether the rent is going to be paid daily, weekly, or monthly. You'll notice there is a blank for essentially what rent will be in the event that a seller fails to timely vacate the property. And this is why it's really important for there to be a number. This creates basically an ability for a buyer to be monetarily protected in the event of a seller does not timely vacate. And if you don't fill in a number, if the number is 0, 200% of 0 is 0. So it's really important to have some amount of rent so that sellers cannot indefinitely stay without, kind of defined financial consequences of that. So this is really trying to protect both parties by creating a rental figure, if the extension goes beyond the time that the parties intended, that is not punitive in nature, but is significant enough to where the parties feel compensated. So it's very important for that to be filled out. And again, this is going to be consideration, monetary payment, in addition to whatever the contractual price was for the purchase. The next section is just creating the obligation that sellers are going to keep the utility services in their name until the possession date. So it relates back to kind of when is possession going to end. I think it's important to realize that although the seller may have the right to vacate early, this is creating the obligation to keep those utilities in their name until they're going to give up the possession of the property. And that's to make sure that obviously we don't have a period where service is not in place, or we have reconnection fees and those types of things. The next section is actually an option as well. And because it's kind of buried on the second page, we have put an initial section there that the parties should both make their selection and also initial. And it's an important thing because it's about the maintenance of major systems and who's going to be responsible for those. It does create a notice provision where whoever is responsible has to provide notice, but it's creating kind of a checkbox situation for the parties to decide who is going to be responsible for these major maintenance issues if they happen to arise. Again, this is very unlikely probably if you have 24 to 72 hours of post-occupancy, but if it's a situation where that's going to extend for a week or 10 days, those types of things become more likely or possible. So we're trying to create a situation where the parties have the freedom to negotiate about the responsibility for maintenance of those major systems. I would expect that there'll be a correlation between who's responsible for maintenance and what the rental sum may be. The next section here, section 3F, is talking about basically the seller's obligation not to make modifications or big changes to the property or even the appearance of the property without the prior consent of the buyer. Obviously, the buyer is now the owner of the property, and so we want to protect the buyer from the seller unilaterally making decisions that are going to substantially alter the property or any of the improvements there too. The next section is talking about just making sure it's very clear, regardless of who's responsible for major maintenance systems, or systems maintenance, that the seller is going to be responsible for any repairs that are required by their use or occupancy of the property. So seller, unfortunately, drops something and damages flooring on their way out the door. That's something that they cause, they're going to be responsible. That's just an example. But anything that's causes of any need of repair caused by the seller's use or occupancy, would create a presumption the seller is going to be responsible for that. You can see as we work our way through this form why consulting with an attorney is important. We've made a lot of areas where parties are going to have some freedom to negotiate, but we've also made a lot of presumptions about responsibilities. And it's important, for the parties to really understand this form very clearly before they enter into it. And I would advise it's not a good idea as agents to be accepting responsibility for giving that kind of advice. They need to consult with an attorney in their local jurisdiction. The next section here, 3H, is just creating making it clear that the continued occupancy and possession of the property is going to be subject to all laws, regulations, ordinances, and statutes in that particular jurisdiction, making sure that the seller is going to continue to abide by any condo or homeowners association rules and regulations, and basically make sure that their use of the property is consistent with all applicable law, so that buyers aren't held responsible for some type of nuisance or a violation of an HOA restriction that results in a monetary penalty to buyers. So the sellers are going to have to continue complying with those types of things. The next section is basically giving the the buyer, who is in this situation going to become the landlord, the ability to inspect the property if necessary until the possession date, whether it's to make repairs or to ensure that it continues to be occupied and utilities are on, those types of things. It gives buyers the right to continue to inspect the new property they have purchased. The next section is again back to insurance, and this is also talking about indemnity. And the idea here is, yes, we're going to have insurance, but we're going to make sure that to the fullest extent possible, buyers are going to be indemnified against claims that are the result of the seller's continued occupancy of the property, or their guests or visitors that come. So we're really trying to protect buyers. Most of the time, the post occupancy is going to be for the convenience of the seller, not the buyer. And so there is a presumption here that we want to have the indemnity that is going to exist to protect those buyers. The next section is to make clear despite the relationship between the parties, we don't want to have the borrowers, or the borrowers to be responsible for amounts owed to potential third parties as a result of the actions or the activities of the seller. So what this is aimed at is primarily mechanic liens, not have a seller come out, have some cost that's due and payable to a third party due to a repair or an improvement, and then have the buyers be responsible for that without their knowledge of it. So it's trying to maintain kind of, hey, sellers may continue to occupy, and this is really probably in longer term post occupancy situations, 30 days or so, where a seller wants something more significant done, but it could be anything, a cleaning bill, lawn maintenance, whatever. And we're trying to make clear that sellers can't bind the buyer to be responsible for those things. Paragraph 4 is kind of the typical default provision that would be found in a residential lease, or it's a form of one of those. And the idea here is to make very clear about how the buyer can enforce this agreement, and what the remedies are going to be. Again, this clause is not perfect for all jurisdictions. It doesn't take care of all potential ways that judges may view a residential lease agreement, but it does at least create a baseline for how buyers can affect seller default, primarily their failure to vacate on time. And so this is kind of typical default language, but again, buyers and sellers need to consult with an attorney in their jurisdiction to make sure that this language is suitable for where their property is going to be located. The next section is really what I would call a merger clause. The idea is to make sure that everyone's aware that the agreement between the parties as it relates to post occupancy is what is in this document, that oral promises that may have been made or agreements that were made are not going to be enforceable, that the agreement about post occupancy is reduced to this document. It also is talking about how if certain provisions in this agreement are not enforceable, that the rest of the document will remain enforceable. That's important because, again, depending on where this form is utilized, some of these provisions are not enforceable, depending on the location of the property. Things like attorney's fees are not enforceable in all jurisdictions. And it's important that if any claim or any clause of this agreement is held invalid, that we want the remainder of the agreement to be valid. And so this is creating that presumption within the agreement. The next section is to make sure that in the unlikely event that maybe a party passes away during this post-occupancy agreement, that their heirs and successors and assigns would be bound by it. So the idea is to make sure that after the parties make an agreement to allow for post-occupancy, that any other party claiming kind of rights under that agreement are bound by it. Paragraph 7 is making it explicitly clear that in the event that somehow this form gets executed prior to the closing of the contract and the contract is terminated, that the addendum is also terminated. So again, we're advising folks that this should not be executed until the closing table, but I understand that mistakes can happen and people can choose to do things differently. And so this is making clear that, okay, the contract's terminated, so the post-occupancy is going to be terminated as well. Next section is kind of re-emphasizing how notices are going to be given. Again, this is to be protective of agents' termination of their rights and responsibilities and making it clear to the parties that they are going to be responsible for communicating directly with one another and no longer communicating with their agents. So it's very clear here that the notices that are due under this agreement shall be given directly between the buyer and the seller. The next section is basically getting the parties to acknowledge what we've talked about a number of times, and that is this agreement is not going to involve either the agents or the brokers. So the parties are going to explicitly not acknowledge and initial here that they're not going to hold their brokerages or their agents responsible for this lease agreement. They've been advised to get competent legal and tax advice prior to signing it. And this is really to provide some protection to agents if they're going to provide this form, to really explicitly have the conversation with the parties, make sure that this part of it is initialed so that they're not responsible for any breakdown or dispute that arises later on. The next section is really just kind of some legalese about making it more enforceable and clear. And that is to make sure that everyone knows it's not effective until it's signed by everyone. We're trying to make clear that this does not in any way alter the terms and conditions of the contract, that to make it any more valid or enforceable or lack enforceability, and also to make clear that the remedies, unlike the purchase contract where certain things terminate at closing, here we're going to make sure that the rights and remedies of the parties under this addendum actually survive the addendum. So once the post-occupancy period ends, the sellers leave. If they've caused a lot of damage to the property, for instance, the new buyer still has the rights to kind of enforce this agreement. There's a lot to this. It's a very dense form. We think that it's a substantial improvement over the post-occupancy that previously existed, but it's a new form that's going to require kind of a lot of thoughtful consideration by the parties as to the rights and responsibilities they're going to have under this agreement. I cannot emphasize enough the importance of individuals getting competent legal and tax advice about this form, and doing so from people in their jurisdiction. One of the things as staff and I have talked about this form, we believe one of the major benefits of being a member of Bluegrass Realtors is access to forms and having the ability to provide resources to your clients and your education and advocacy to your consumer clients. But this is a situation where we feel it's really, really important to be careful. And that is why, in large part, the pre-occupancy form has been removed. And why although we've improved this form tremendously, we're really encouraging people to get the competent legal advice of a local attorney and to try as best as possible as agents and brokerages to remove ourselves from advising our clients about this form. It's a tool that can be available to them, but we'd strongly encourage them to get competent local advice. With all that said, thank you for your time today, and I wish you great success in the upcoming year.